Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, bills brought from the House of Representatives on the supplemental order paper, the Kabir Association of Trinidad Incorporation Amendment Bill 2019.
Honorable Senators, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken later in the proceedings. Those in favor say aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken later in the proceedings.
Papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The annual report of the First Citizens Bank Limited for the financial year ended September 30, 2019, and the annual report of Taurus Services Limited for the financial year ended September 30, 2019. Thank you, Madam President.
Madam President, my apologies. Madam President, I have the honor to lay on the table the following papers as listed on the order paper, the names of the Minister of National Security and the Attorney General. The response of the Trinidad and Tobago Police Service to the 25th report to the Public Administration and Appropriations Committee on an examination into development program for the fiscal year 2018-2019 and follow up on the ministerial response to the 6th report of the Tobago House of Assembly. The Trademarks Regulations 2020, the Trademarks Border Enforcement Measures Regulations 2020. I thank you.
Reports from committees.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The third report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, 5th Session 2019-2020, 11th Parliament.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the names of the Minister of National Security and the Attorney General.
No,
Oh.
of Rural Development and Local Government should have been presenting a report. Is there anyone who served on this committee? It's a committee report on human rights, equality, and diversity. Any members here? Then I'll stand it down. All right?
Urgent questions?
Senator Mark.
Thank you, Madam President. To the Minister of Rural Development and Local Government, given the extremely bad weather, which destroyed several homes along the east-west corridor, can the Minister indicate what measures are being taken to directly assist the affected residents?
Acting Leader of Government Business.
Thank you, Madam President. Madam President, as we all know, the Met Office had issued warnings relating to the weather system, which was likely to affect the country on the weekend. And just before 6 a.m., the weather system materialized across the country with heavy rains that started in South and in East Trinidad and made its way across Port of Spain by about just before 7 a.m. Madam President, the disaster management units across multiple corporations responded to several reports of fallen trees, branches, and blown off roofs over the weekend as a result of the inclement weather. And those trees would have been from Cleaverwood Park in Arima, right across the east-west corridor, down to Port of Spain, where we had several incidents. In keeping with the Ministry of Rural Development and Local Government's protocols when dealing with a disaster, the disaster management units were immediately activated along with the corporation personnel such as tree cutters and equipment operators. Where required, agencies like TNTEC, Fire Services, Police Service, Municipal Police, Ministry of Agriculture, Forestry Division, and Ministry of Agriculture, Horticulture Services Division, in addition to the Zoological Society, were called upon to assist. Disaster management units coordinated the tree removal exercise, debris removal, the cleaning up, the provision of tarpaulins in the case of places where the roof was blown off, and other relief items in accordance with the established protocol. Additionally, assessments were conducted in accordance with the protocols established by the Ministry of Social Development and Family Services, and those relief programs are going to be put into effect, and relief is expected to be provided this week. I thank you.
Yeah, I'll go on to the second question.
Okay. Next question, Senator Mark.
To the Minister of Rural Development and Local Government, given the threat posed to the residents of Upper Bournes Road and the surrounding community by a potential landslide, which could result in damages to nearby homes and buildings, what measures are being taken by the relevant agencies to address this situation?
Acting Leader of Government Business.
President, since before March 2020, in fact, late last year, Madam President, the Ministry of Rural Development and Local Government, together with the Ministry of Agriculture, which has responsibility for state lands, began taking note of the private development, that is a private development on Upper Bournes Road, a private development, and speaking to the contractors who are on site. Of particular interest to us was the risk of rain and the potential for flood coming down that hillside with the removal of the the grass and the trees that would normally hold the soil in place. Those discussions continued through the COVID period. The contractors approached the government to conduct certain work during the COVID restrictions to deal with the possibility of problems with the soil and erosion if the rains came. The contractor has been taking the appropriate steps to contain any risk. The agencies continue to monitor, including the corporations, the Ministry of Agriculture, and the EMA, and would ensure that steps are taken, particularly given the weather patterns, to ensure that there's no risk to those houses which are just beneath the development. I thank you.
Madam President, could the Minister indicate what specific steps are being taken by the developer along with government agencies to avoid any untoward dislocation by those residents whose homes are in the immediate vicinity of this particular emerging landslide?
Minister.
Madam President, the developer is in constant contact with the residents. The developer has representatives on site speaking to the residents. The developer accelerated the benching of the sites, which would cause a reduction in the potential for soil erosion. The developer has accelerated the development of the drainage on the site to ensure that water runs off. It doesn't come onto the Upper Bonds Road area. And the developer has put in place emergency measures, including having water and the access to the equipment on site. There's a contractor nearby, access to the equipment on site in the event that
Minister.
unusual rainfall brings further damage. Okay, thank you.
Next question, Madam. Yeah, Madam President. Question number 3 to the Minister of Health. In light of reports that bar owners and patrons continue to ignore COVID-19 protocols, can the Minister indicate what steps are being taken to address you?
Minister, Acting Leader of Government Business.
Madam President, I thank Senator Mark for this question, and I know almost every citizen of this country is paying attention to this particular issue. And the short answer is that the Minister of Health would be making an announcement with respect to the steps which are being taken at the press conference which is being held at 11 today. The government has already signaled to the bar owners across the country that we expect compliance with the COVID measures, and the Minister intends at 11 a.m. to address further matters relating to that issue.
Madam President, this is the Parliament, and I don't have to wait for a minister. Madam President, may I ask the Honourable Minister whether concrete steps have been taken to meet with the relevant association representing bar owners with a view to rectifying the situation?
Madam President, it is public knowledge the position the government has taken. The position of the government has been made clear by the Honourable Prime Minister himself. The bar owners, through their association, has responded. The suppliers of alcohol to bars have responded. They have their own association, the Alliance. And as I said, I don't think there is need for further consultation. The government has set out its position. The owners and operators have set out their position, and the distributors of alcohol have set out their position. And based on that, the Minister of Health would make the necessary announcements at the 11 a.m. press conference.
And Senator Mark.
To the Honourable Minister of Health, having regard to the discovery that some locally produced hand sanitizers contain toxic substances, can the Minister indicate the steps that are being taken to withdraw these products from the market?
Acting Leader of Government Business.
Madam President, in accordance with the law and the established protocols, a matter of this nature is addressed via the Chemistry, Food and Drug Division of the Ministry of Health and the Bureau of Standards, which forms part of the Ministry of Trade and Industry. And the Bureau of Standards and the Chemistry, Food and Drug Division, they have taken the steps to have any product that does not comply with the appropriate standards, in particular hand sanitizers, would be removed from the shelves. Thank you.
Madam
Senator
President, can I ask the Honourable Minister whether these hand sanitizers were initially approved by the Food and Drug Division of the Ministry of Health?
Madam President, the mere fact that they have been removed from the shelf by the work of the Chemistry, Food and Drugs Division and the Bureau of Standards suggests that they have not met, they do not comply with the appropriate standards. So what is on the shelf and what is on the shelf now and what is to be removed have not met the standards of the Chemistry, Food and Drugs Division and the Bureau of Standards.
Senator Mark, the time for urgent questions has expired.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, the government intends to respond to question number 144, 155, I believe, no, question number 142 and 44 and 172, and we're asking for deferral of the other questions.
Can you guide me, Madam President?
Yes. So answers will be provided today to 144, 155, and 172.
144 and 155, Madam President. My apologies.
Okay. So questions 144 and 172 are deferred for 2 weeks.
No, Madam President.
Let's go again.
I'm sorry for...
No, that's all right.
I'm sorry
The mistake might be mine, so it's fine.
So we are responding to 144,
Yes,
and we are responding to 155.
yes.
We are asking respectfully for referral of 145 and 172.
Okay. Yeah, okay. So questions 145 and 172 are deferred for 2 weeks. Senator Mark?
Yeah, question 144 to the Minister of Education.
Acting Leader of Government Business.
Madam President, following a decision of the Cabinet, a memorandum of understanding was executed on January 16, 2020, between the Permanent Secretary, Ministry of Education, and Imam Yassin Abu Bakr, religious leader of the Jamaat al-Muslimin, for financial support to the Madrasa al-Muslimin Primary School. The terms of the agreement are as follows. With effect from January 2020, January 1st, 2020, financial assistance will be granted to the Jamaat al-Muslimin for the operation of the Madrasa al-Muslimin Primary School, located at number 1 Mukapu Road, St. James, Port of Spain. And this assistance includes funding per term to meet the payment of utility bills, namely telephone, $400, electricity, $300, and water and sewage, $200. A monthly grant to be used as a contribution towards the payment of salaries of teachers, which would include $6,483 per month towards the salaries of teachers who are registered with the Ministry of Education and who meet the requirement of 5 GC CXC ordinary level subjects or equivalent, including maths, English, and a science subject. $5,000 per month towards the salaries of teachers who do not meet the minimum requirement, and a flat sum of $1,000 per term to meet operational costs. The preconditions of this agreement, Madam President, are that the school follows the National Primary School curriculum. The Ministry of Education be allowed to assign teachers to teach at the said school after consulting with the management of the school, and the school be subject to the supervision of the Ministry of Education. I thank you.
Senator Mark?
Yeah. Madam President, can the Minister indicate whether this agreement has a period or a duration?
Minister?
Madam President, my apologies, but I do not have that information in front of me.
Senator
Can I
Mark?
ask the Honorable Minister to provide that information to this Honorable Senate?
Minister?
And yes, Madam President, an undertaking to provide the information on the period of the agreement entered into on the 16th of January 2020. I thank you.
Senator Mark?
Madam President, can I ask the Honorable Minister, when did the Madrasa Al-Muslimin Primary School applied to the Ministry of Education for financial assistance?
Minister?
To add to my previous undertaking to provide it in writing in 1 week. Thank you.
Senator Mark? Next question, Senator Mark.
Question, is it 155, Madam Chair?
Yes.
Question 155 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, the tax information exchange agreement with the United States of America and Trinidad and Tobago is in effect and fully functional and is not impacted in any way by any issue.
Senator Mark?
Yeah, I'm happy to hear that, Madam President. I'm cool.
Reports from committees.
Senator Thompson-Aye.
Madam President, I have the honor to present the following report as listed on the order paper in the name of Senator the Honorable Kazim Hussain. The 17th report of the Joint Select Committee on Human Rights, Equality and Diversity, 5th session 2019-2020, 11th Parliament, on an inquiry into persons living in poverty and extreme poverty in Trinidad and Tobago with specific focus on vulnerable groups. I do apologize for myself and for the Honorable Senator being here.
To the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, having regard to the fourth interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, 5th session 2019-2020, 11th Parliament, I beg to move that the committee be granted an extension to August 31st, 2020 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, 5th session 2019-2020, 11th Parliament, be granted an extension to August 31st, 2020 to complete its work and submit a final report. Those in favor say aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Services Act, Chapter 601, the Evidence Act, Chapter 702, the Malicious Damage Act, Chapter 1106, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Services Orders Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Hall Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commission Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children's Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metal and Marine Stones Act, Chapter 8407, the Liquor Licensing Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, 2011, the Criminal Division and Criminal District Criminal and Traffic Courts Act, 2018, and the Electronic Payments Into and Out of Courts Act, 2018, be now read a second time. Madam President, I stand before this Honorable Senate today to bring to the front a number of amendments which seem long in the hand but are actually very closely related. I wish to state that as a result of the process of legislative reform that we have engaged in over the last 5 years, that we have very successfully managed to implement almost all of the laws that we have passed. In the course of that passage of laws, we of course have done so much amendment that it is necessary in the course of operationalization that we now harmonize amendments across multiple platforms. For instance, Madam President, immediately I can refer honorable members to the fact that clauses 18, 19, 20, 30, 31, 32, 34 are all related to one amendment which we have caused in law. Similarly, Madam President, the amendments that we bring before the House are related to the operationalization of the criminal justice reforms. Equally important to the positions in the amendment to the package of laws to treat with children and motor vehicles. In the very truncated time that we have, permit me therefore to dive immediately to the bill, to raise issues that are in common, and then to rely upon the explanation for these across the various laws which echo the need for these amendments. Obviously, Madam President, you'll notice the short title at Clause 1 and the commencement provision at Clause 2. The commencement is there specifically because in the course of operationalizing law, we are sure to write to stakeholders to ask for their readiness, and therefore we have the ability to proclaim this law in parts if necessary, depending upon the operational readiness for the implementation of law across stakeholders. The amendments at Clause 3 to the Interpretation Act are very important. You will know, Madam President, that we introduced the concept of the clerk, and that magistracy clerk now stands in place of the clerk of the peace. Prior to the amendments which we did, across the Family and Children Division and the Criminal Division and Traffic Courts Act, you will note that we had an unqualified person, meaning an attorney at law was not present in the shoes of a clerk of the peace, notwithstanding the fact that the clerk of the peace in fact engaged in what seemed to be the practice of law in breach of the Legal Profession Act. We therefore seek to insert into the Interpretation Act so we can tidy up the references to clerk of the court or clerk of the peace by specifically referring to the terms the senior magistracy registrar and clerk of the court or the magistracy registrar and clerk of the court. Similarly, this allows for the following events: the full abolition of the concept of clerk of the peace, which we took care of in earlier laws. With the passage of the Criminal Division and District Criminal and Traffic Courts Act, number 12 of 2018, the new designations that we brought into effect saw for the first time the administration of the magistracy across its summary court jurisdiction and petty civil jurisdiction via the use of the equivalent of a registrar of the magistrates' court. I cannot underestimate to honorable members the severe importance, the critical importance of that amendment. That has allowed us to bring much needed efficiency to the criminal justice system where the vast majority of cases are heard in the magistracy. Madam President, it's important to note that in this particular amendment, we also ensure a reference to collecting officers. Why? We have, in fact, with the electronic transactions introduced into the court system via the payment into an out-of-court legislation, it's important for us to put into the Interpretation Act the definition of a collecting officer to allow us to have that done not only in manual systems at the court, but by way of electronic transactions, as currently happens. Madam President, the amendment to the Summary Courts Act in Clause 4. We introduced very important terms. Obviously, we harmonize the reference to clerk to mean the magistracy's registrar, if I use that truncated term. But importantly, we're now introducing the court location. What is this about? Perhaps members hadn't noticed. We, by order, amended the number of magisterial districts in Trinidad and Tobago to 3. Those magisterial districts are now Tobago, North Trinidad, and South Trinidad. What does this mean? It means that we no longer have to go to a magisterial district. You get a traffic offense in Rio Claro, you live in Scarborough, you're bound to return to Rio Claro because it's in that magisterial district. Now, pursuant to this amendment, the Chief Justice has the ability, taking into account the Criminal Division Section 24, where we create specialist courts, taking into account Legal Notice number 99 of 2020, where we reduce the magisterial districts to 3, we can now use court locations. This is critically important because we now have video court conferences at the prisons, for instance, where we've installed 12 courts. We stopped transporting prisoners. We now have had over 3,000 matters at the courts, saving this country $25 million a year in prisoner transport. We very importantly anchor the concept of video link, and we sought to put this into the Summary Courts Act. You'll see it in the Petty Civil Courts Act as well, where we put in the video link so that we can deem where the trial is being heard by way of a video conference. We can actually have the technological equipment by reference to what are the basic requirements, that all parties are heard, the judge, the parties, the interpreter, etc. We very importantly now give magistrates the jurisdiction throughout Trinidad and Tobago. No longer are they shackled to the magisterial district as to where they can hear their matters, and we allow the Chief Justice by order to designate locations in each district. This is critically important when we're looking to liquor licensing, specialist courts such as the gun court and fraud courts, and the petty civil arena, which will become operational very shortly. But these are critical reforms to changing the criminal justice system. Madam Speaker, Madam President, of course, we then seek to further harmonize throughout the Summary Courts Act the references to court locations in districts, as we now have 3, and we allow the Chief Justice by practice direction to determine those court locations. Critically, we now allow for records at courts to be specifically held electronically. We know that this country suffered because of the manual record keeping at the courts. And now that we have the FTR technology, the video recording technology in every magistrate's court and every court in Trinidad and Tobago, now that we have revolutionized the court system, it's important that record keeping be allowed to happen in an electronic environment. We've allowed for the assignment, reassignment, and designation of magistrates and court locations via the Chief Justice, exactly as we have in the High Court arena, bringing the High Court lessons that we have learned and the successes we have had in the civil division in particular across the magistracy, bringing it into relevance finally. Madam President, we have also allowed the concept of the keeper to be managed for the collection of fines, fees. Now, of course, you know there are three types of revenues that you keep at the magistracy court: fines, fees, and then, of course, you have the concept of payments, which are interest, such as maintenance, etc. We've had to define who can keep these positions and the manner in which they are kept in electronic form. We've tied it into the transmission to the accounting officer in anticipation of the public procurement laws coming into full effect, and specifically because of the financial instructions under the Electronic Transactions Act. Madam President, we have also allowed for the management of fees which are not taken care of traditionally to be done by way of the rules of the Supreme Court in an introduction of a new section 21A. Filing of documents, service of documents, convenience fees, technology, use of mediation, all of these alternative mechanisms have to be managed, and instead of having it done on an ad hoc basis, order by order, we ask for this to be done by way of rules of the Supreme Court so that the bar and bench are involved in what the establishment of fees look like, strictly regulated. We have very importantly sought to harmonize the statement of offense, Madam President, so that we have a clearer picture. This statement of offense in criminal matters is critical as we go to an electronic transformation of the courts. The judiciary, the public defender, the DPP's office, and the police are now, thanks to the Attorney General's office and the combined effort of these entities, all on the same technological platform. Because of the use of court mail, where we issue out the orders and we have a unified electronic room, this allows us to have uniformity in the filing of documents, in the filing of criminal complaints, for the first time, accelerating the pace of justice radically and in the interest of justice. Madam President, we've cut and pasted these amendments across the Petty Civil Act. That is in Clause 5. May I ask what time I end in full time?
You have 17 more minutes. You end at 10:55.
10:55. So, Madam President, Clause 5, which has the Petty Civil amendments to Chapter 421, court location, clerk, magistracy sitting in petty civil, removing the nomenclature issues of the judge sitting in civil arena. I should tell you now that we have prepared amendments to the civil arena to create the civil division, with a subset being the small claims court. The small claims court will critically have judicial mediation annexed to this, because the limit is $50,000. We don't want people to have to spend obscene amounts of money on their attorneys at law when court-annexed mediation is the solution to this type of mechanism. Again, radical transformation of the judiciary. Madam President, we basically adopt the rationale for Clause 3, Clause 4 into Clause 5, asking honourable members to accept the rationale that I've given for the Summary Courts Act to the Petty Civil Courts Act. Transfer, location, court locations, maintenance of records, etc. Clause 6 amends the Sentencing Commission. What we do now, because we have the JEI, the Judicial Education Institute, is we harmonize all reports from the Sentencing Commission to move to the Chief Justice, and therefore the Chief Justice via the JEI and the Judicial Coordination will then harmonize the work of the Sentencing Commission as we bring that Sentencing Commission into full life. Clause 7 amends the Judicial and Legal Services Act. Very critically, we're cleaning up the references to court executive administrator and master. We already made those amendments in law. I gave the undertaking to do that. The reference to master was the anomaly of the master having to fall under the jurisdiction of the registrar, which is wrong. the magistrate, the master ought not to be under the registrar, but instead under the Chief Justice. Importantly, we are asking for the insertion of the magistracy registrar and clerks of the court, because they were not in the parent act, they were just in the schedules. You need to put the operative terms and conditions into the parent law. We have then put out the functions of the senior magistracy and clerk of the court, senior magistracy registrar and clerk of the court. Why? Even though these functions were in the criminal division law, we needed to put it into the Judicial and Legal Services Act so that we could harmonize these positions. We've set out their functions at law, effectively mirroring from the respective pieces of law and harmonizing into the Judicial and Legal Services Act. We have, Madam President, also allowed for the Registrar General to move to the terms and conditions of the senior officers of the state, the DPP, the Solicitor General, the Chief State Solicitor, the CPC. We have allowed that because the Registrar of the Registrar General at the Ministry of Legal Affairs has massive functionality under the amended laws that we have caused: non-profit organization, beneficial ownership, FIU, real estate agents, registration of deeds, running thousands of employees with thousands of persons accessing the Registrar General's services on a daily basis. And it is high time that that anomaly of 14 years of song and dance is finally concluded in legislation. Madam President, I turn next to the Evidence Act. We had to insert the reference to Senior Magistracy Registrar and Clerk of the Court. This is, of course, to substitute the Clerk of the Peace. Similarly, Clause 9, which deals with the Malicious Damages Act, we wanted this law to be managed so that the judiciary had rule-making power to assist in developing case management strategies. This is an underutilized provision of the law for malicious damages, and as we birth the new system of justice in this country, we are cleaning this up. The coinage offenses under Clause 10, we are looking specifically to include the Justice of the Peace. The Justice of the Peace is authorized to handle evidence seizure. This is an anomaly at law which needed to be cured. It is because of our concentration on the administration of justice that we're aware of that. I turn next to the amendments in Clause 11 to the Sexual Offences Act. We had agreed on the last occasion when we amended the Sexual Offences Act that we should do this by negative resolution. I had done that in the debate, and I have therefore kept the undertaking before the Honourable Senate today. The amendment in Clause 12 to the Indictable Offences Preliminary Inquiries Act is to treat with the concept of keeper. What does this mean? It's simple. The law currently requires that a police officer must go and get the prisoner and bring the prisoner to court. What happens if you've done as we have, which is to take the court to the prison? You no longer need to have the police officer moving up and down. You instead have the keeper at the prison managing the movement to the court, which is at the prison. And therefore, this is a harmonization for the over 3,000, nearly 4,000 matters as we move forward that we are hearing from the prison courts in the virtual courts that we've set up there. We've amended at Clause 13 the Community Services Order, again harmonizing court location and clerk, etc., keeping the amendments as we did to Clause 4 and Clause 5, close at hand. Clause 14 treats with the amendment to the Defense Act. This is a critical amendment. We're adding in a vice CDS so that we have succession planning. We're adding in interdiction via due process so that the president for commissioned officers or the CDS for non-commissioned officers can interdict people. Now, you'll see a reference to a civil offense. Note that expression. Civil offense in the Defense Act means a crime. It is not in reference to civil law. It is to allow for people who are on charges in the courts to be the subject of due process interdiction, docking of salaries, etc., in a full environment. This takes us out of the anomaly of paying for persons who are in jail or incarcerated, where the Army has the ability via the President, and I mean across all the divisions, the TTDF, via the President and via the CDS to now regulate its affairs to bring law and order into the TTDF. We are seeking to create the Air Guard Wing. It is something which is long overdue in the Defense Act, and this is something which we're very pleased. I pay salute to Sheldon Ramnanan, who who has organized these amendments coming via the CDS, the hardworking CDS, back to back from the previous CDS to the present one in causing these amendments. Madam President, we've amended the Firearms Act at Clause 15, quite simply to take care of the COVID relief where licenses could not be paid. We have put in the springboard for the extension of licensing terms and provisions, as you see appearing in the bill. We've amended at Clause 16 the Explosives Act to introduce the term clerk, again borrowing from the whole concept of the magistracy, registrar, and clerk of the peace. This needed to be added in there. The Registrar General at Clause 17, we have a small amendment to circulate at committee stage, but what we're doing here is really a radical bit in preparation for the laws that we operationalize. We're allowing for the registrar to keep electronic records. Why? For accounting, because we have already gone online. And as we broaden the fact of all payments for companies, all payments for land transactions going via electronic transactions, it's necessary to have the law catch up with this as we're operationalizing our way into thousands of success points going ahead. We'll amend the reference to the days. You'll notice that every carnival period, you see the registrar forced to pay for an ad in the newspapers to say the RG is not going to be open on Carnival Monday and Tuesday. That just required a tweak to the law, which we're proposing here. Clause 18, 19, 20, Cinematograph Act, Registration of Clubs Act, amendments to the Theatre and Dance Hall Act. And then when we get down to clauses 30, 31, 32, 34, these are all to take care of the amendments which we have done in introducing the concept of the magistracy registrar in place of the clerk of the peace. We had to amend the provision because clerks of the peace have been abolished. Now we have the registrar effectively sitting across these committees, liquor licensing, cinematographs, theaters, dance hall, members clubs, etc. It's to harmonize the law. We put the secretary into law for the first time as a person inside of that committee, and we allow for a better functionality across those divisions. The Electronic Transactions Act at Clause 21, this is a radically important amendment. It allows us by way of regulations, and I can tell you we have drafted them already, to launch the entire electronic payments across Trinidad and Tobago. The certification is better done by way of regulation as opposed to Parent Act certification, as you see in Section 32 of that Act. Clause 22 amends the Elections and Boundaries law. That's to allow for the laying of the local government report. The EBC, due to the closure at COVID, could not bring the report forward in time. It's laid in Parliament, but it's out of time, and therefore we must amend the law to allow for the laying of that report. Clause 23 amends the Mental Health Act. We're putting the functions to deal with psychiatric hospital tribunals into the Chief Justice, because the Chief Justice with our specialist courts has a better autonomy and better jurisdiction to manage who ought to sit on these tribunals as opposed to necessarily inundating the Chief Magistrate. We amend the Children's Act to amend the concept of grooming. This was something which was long overdue. The rectification process in the 2012 Act had an erroneous reference and distinction. We needed to remove that. Importantly, in the Children's Act, you'll see we're adding in child traffic violators. Children get their license at 17. They are therefore still children. Child traffic violators must be treated separately. They must be referred to child traffic counseling. They must be made to organize themselves outside of the criminal law. This improves and moves on with the amendments that we have done to treat our children differently. I know Senator Thompson is going to raise an issue that I don't have time to treat with in the piloting, but which I will deal with a little bit later. Suffice it to say that other issues of the age of discretion that we're looking at, I've consulted with the judiciary. We're not quite yet to treat with those amendments. I asked specifically at the Honourable Senator's inquiry, which she made personally to me, but I'll explain that in greater detail later. We've amended the Motor Vehicle and Road Traffic Act at Clause 25. Again, we've added for the continuation of validity. We're looking at the licensing for driving permits, taxi drivers, badges, etc., for motor vehicle registration, etc. There's a backlog, and therefore we need to extend the date because extensions are being given by way of appointment right now, and therefore we need to factor how that operationally works. You see the reference to child traffic counseling, the reference to attendance of a child at the child trafficking program, and then the consequences in demerit added into the 9th schedule. 5 minutes. Thank you, Madam President. Clause 26 amends the Conservation of Wildlife Act. And when we look to the Conservation of Wildlife Act, we're amending the ridiculous penalties of $10,000 to a higher sum of at least $100,000. We're managing the appointment of the committee, and the Honorable Minister of Agriculture will treat with that particular point. But suffice it to say, the specificity that the law required was just operationally impossible, and the Honorable Minister of Agriculture asked for these amendments as we've caused. We're amending the Value Added Tax Act, and particularly in that, we're adding in the fact that the issuance of bonds may be taxable or non-taxable. Why? The Minister of Finance has signaled, as we pay off the last few $1 billion of payments, having done so many already, that we allow for the interest that can come on these bonds to be non-taxable, allowing for more money to be met into the hands of persons who receive these bonds. We're amending at Clause 28 the Customs Act, and in particular, this is to keep with the harmonization of the forms for entry. Immigration Act, the health legislation, the Food and Drugs legislation, the Customs Act. We have now, because of the ease of doing business, harmonized the forms. Instead of having the parent law put out the form, and every time you amend the form, you have to come and amend the parent act, you'll see we're saying that the forms are to be issued in prescribed forms. These forms are ready, and we've inserted the definition of a pleasure craft, because a pleasure craft has to be accepted out. We have a large yachting industry here, and this allows for ease of yachting, particularly with the COVID pandemic. We have seen an influx of yachts coming into Trinidad and Tobago as our hurricane belt location outside of it has allowed for greater business. We've had that request coming at us. It is, as the Minister of Trade will speak to, a request which is prospective. We've, of course, with the COVID restrictions, not allowed vessels in yet, but we're getting the knock on the door, and we must therefore be ready for that surge as soon as the Ministry of Health and National Security can manage that. Clause 29. This might seem simple. It's radically important. It is ridiculous to have a name search and name reservation expire 20 to 25 days. We had to amend it to a longer period for the ease of doing business, and we have definitely moved that forward, as you'll see appearing in the legislation, Madam Speaker, now at 45 days. We're amending the Moneylenders Act, the Pawnbrokers Act, the licensing of dealers, precious metals, old metal marine stores, liquor licensing, as I've said earlier, to catch the fact that we've abolished the Clerk of the Peace. We now anchor the secretary into the committee. We make sure that they are paid properly, and we put them into the municipal corporation in which they appear. No longer magisterial district, as we've simplified the magisterial districts. Clause 35, we amend the Administration of Justice Indictable Proceedings Act, very critically to include the video link. Very critically to have the reference to the senior magistracy registrar, etc. included. Very critically to allow for the recording of your answer by electronic means. This longhand paper writing concept is anachronistic. The Privy Council doesn't use it. Why should we, especially now that we have introduced all of the technology into the courts? Criminal division, we've added in the reorganization of the roles. That's at Clause 36 for the criminal division and district courts as we have them set out. And the electronic payments into and out of court, Clause 37, we're making drafting reference amendments. You will see, Madam Speaker, Madam President, that this is a very useful operation of Parliament's time. To amend 35 laws, bill by bill, might annoy and anger the leader of the opposition, but it is the opposite of efficiency in the work of the Parliament. If we take the advice coming from elsewhere, that we take an individual bill for each of these things, we'll just never get it done. This is the way we make best use of parliamentary time, and I thank you, Madam President, for the opportunity to pilot this bill. I am sure that there'll be a lot of questions at committee stage, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled, An Act to Amend the Act 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Service Act, Chapter 601, the Evidence Act, Chapter 702, the Malicious Damage Act, Chapter 1106, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Service Orders Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commissions, Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Moneylenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metal and Marine Stores Act, Chapter 8407, the Liquor Licenses Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, 2011, the Criminal Division and District Criminal and Traffic Courts Act, 2018, and the Electronic Payments Into and Out of Court Act, 2018, be now read a second time. Senator Mark.
Thank you. Thank you very much, Madam President. Madam President, you know, I was about to begin by saying, like that gentleman who died in the United States, that I can't breathe. The Senate can't breathe. Madam President, would you believe that the government is using COVID-19 to stifle the rights of our bench to speak in accordance with the standing orders? We can't breathe. This is an undermining of our democracy by this outgoing government. And I want to put on record, Madam President, our strongest objection to this continuation of abuse. It is unacceptable, Madam President. But they are out. Madam President, may I say from the very outset, I have never seen 36 bills to be amended in one piece of legislation, and you are giving members of Parliament 20 minutes after my 30 minutes. It is an abuse of the process. It's an undermining of the parliamentary democratic process. Unacceptable. Madam President, there are so many things that I would like to say, and I'm being denied the right of saying it because I don't have the time. So I have to confine myself to one or two measures that are being amended here today. But I want to say very early that power corrupts, and absolute power corrupts absolutely. Madam President, the areas I'm going to touch on briefly. 4, 5, 6, 7, 11, 23, 27, 28, as quickly as I can. I just don't have the time because the PNM decided not to give the Parliament the opportunity to speak in accordance with our Constitution and standing orders. Madam President, the areas that I'm going to look at, I want to summarize them in the following ways before I get on to the specifics. One, the areas I'm going to look at is establishing what I consider to be an unprecedented concentration of power into the hands of one office holder, which represents the manifest undermining of the office of other office holders. And Madam President, it does two things. You are concentrating power in the hands of the Chief Justice, and at the same time, you are removing power from the Chief Magistrate. That's the first area I have been able to discern in this matter. And I want to ask the Attorney General when he's winding up here, who is the author of these amendments? Is it the CPC or is it the judiciary? You must clear the air on these matters when you're winding up. Madam President, the second area I am seeing in this particular package of amendments, which is strangulating us, strangling us, forcing us not to breathe, Madam President, is the undermining and dismantling of the scrutiny role of the Parliament. And the government is infringing the rights of the citizen by removing, later on I will show, affirmative and replacing it with negative. Madam President, the third area I'm seeing emerging from these amendments is an undermining of national security in order to make the rich richer and the poor poorer. By removing, Madam President, is making the rich richer and the poor poorer by making bonds issued by the government non-taxable, as the Attorney General just said. Madam President, this has come on the heels of an earlier amendment and a public officer in the persona of the Comptroller of Customs and Excise and replacing him by politicians to make bonds transferable. So the government has brought 36 amendments aimed at confusing us in this Parliament and obfuscating very critical and dangerous and far-reaching provisions in the legislation that is before us. Madam President, if I can quickly go to 4, Madam President, 3, Roman 3, Madam President. And the last area that I've looked at, Madam President, in summarizing which is amending Section 7 of the Summary Act, which is before us today. This seeks to empower the Chief Justice to make a wide discretion without a formal docketing system or such other system that is free from prejudice, Madam President, to transfer, Madam President, this Parliament and make laws, Madam President, that is going to undermine the rule of law and our democracy. We are not going to permit that. So, Madam President, I am saying to the government, if you want to make the Registrar General a legal officer, amend the law and do that. But don't come here in a surreptitious manner and equate the Registrar General with that of the Solicitor General by making a chief legal officer. How can you do that? You can't do that. The government, Madam President, this is unacceptable. And I'm going to serve notice on this Parliament through you that we are going to be proposing a number of amendments to this legislation, Madam President. They could reject it. They could not. They are bound to accept it. But, Madam President, what the Attorney General and the government is doing is totally unacceptable. they are creating a monarch. They are creating an emperor. They are creating a powerhouse in this country that will come to haunt them, Madam President, in the final analysis. And in this regard, Madam President, I will propose and circulate the relevant amendments to deal with all the deficiencies and weaknesses that I have discerned in this piece of legislation on behalf of the United National Congress, the incoming government of the Republic of TNT.
Senator Thompson-Aye.
Thank you, Madam President, for the opportunity to join this debate on the miscellaneous bill, amendments bill. It took the Attorney General 2 minutes to read just the title of the bill, so it's the longest in history, perhaps. Thank God you were able to read a little faster than he was. Now, this exercise of amendment of existing legislation reminds me of a story I heard as a child during one of our many biannual vacations in Mayaro. Every Easter and August, we would head up to Uncle Horatio's house, and one of the favorite things about it is that we would tell stories. So in addition to the beach and the fish, storytelling. And there was a story I particularly loved, written by James Baldwin. And it was the endless tale of the king who had nothing better to think, nothing better to do than listen to stories, and he wanted a story that had no end. So his prospective son-in-law came and told him about the locust and taking a little grain of corn. So the corn heap was so large, the locust came and took another grain of corn, the locust came and took another grain of corn, and so on and so on and so on. Now, this Senate in June 2018 facilitated a giant step forward for the judiciary by passing legislation to establish a criminal division and division of the summary court to be known as the District Criminal and Traffic Court. And on that journey, it paused to take a little grain of corn, and we put in the second schedule, the Judicial and Legal Service Act. What we put in there is senior before magistracy, registrar, and clerk, and we're gone. Then we return on March 17, 2020. For more than one grain of corn, we amended Section 215 of the Judicial and Legal Service Act by Act 8 of 2020 to include the Chief Judicial Officer and terms and conditions, and we're gone, and here we again. We are here to amend the Judicial and Legal Service Act, among other pieces of legislation, but I want to focus on that piece of legislation. We are amending 35 pieces, but and when we finish, I suppose we're really gone. But before I do, I want to make some observations, ask some questions, and express some concerns. Now, doing this work, this legislative work, passing legislation, amending legislation, is hard work. And we are always grateful, if I may be so bold as to speak for my fellow senators, for all the assistance that we can give. And one of the areas that we find that we're grateful for is the explanatory notes that come with the bill. It makes our life easier, or should. But in this case, it brought confusion. So it therefore created a problem for me. When we look at Clause 7, it says that subsection 1 of the Act is mentioned. It doesn't name the section. So by a process of deduction, I suppose it to mean Section 15. The part of the note which promised but did not deliver says, and for the removal of the obligation for masters to report instead to the registrar, but will require masters to report instead to the court executive administrator. Now, that is so puzzling. I don't know if it was supposed to be a Freudian slip or what. It didn't sound like English, and that was not delivered any part in the bill. I waited to see if the Attorney General would bring some clarity to clear up this wording here, but I am still waiting, so I suppose in his winding up, he will explain how this happened, what does it mean in the bill. It is irritating and off-putting. Again, looking at the explanatory note, when you look at clause 25, you see that it talks about bad certificate, BAD. I assume, again, I'm making a lot of assumptions, although I know what happens when you make assumptions. And it talks about bad certificate, which I assume is birth certificate, but when you actually look at clause 25, it says nothing about it. But it was extending the time, for something. So if those things could be clarified, I would be exceedingly grateful. It makes our life a bit harder when we have these puzzling areas of the bill. Now, I want to focus on clause 7, as I said before. Terms and conditions of the registrar are set out in section 12(1) of the Act. The Ministry of the Legal Affairs shall comprise the departments of civil law, of criminal law, of legislative drafting, and of accounting, which shall be headed, respectively, by the Solicitor General, the Director of Public Prosecution, the Chief Parliamentary Counsel, and a public officer to be designated permanent secretary in the ministry. So you have these major officers who exercise functions that the permanent secretary, who is also the one who carries out the duties in the ministry under the direction, general direction of the head, whoever is a minister designated. So you have those particular persons. And then you have 12(2), which says the civil law department shall include the departments of the chief state solicitor and the registrar general. And when we go to 12(3) now, it says, for the purposes of section 85 of the Constitution, a chief legal officer is a permanent secretary. When you look at clause 7(1)(c), it says the terms and conditions of service of the Registrar General shall be equivalent to those of a chief legal officer. When we look at the Judicial and Legal Service Act, for the definition of chief legal officer, it means the Director of Public Prosecutions, the Solicitor General, or the Chief Parliamentary Counsel. So this bill, therefore, catapults the Registrar General and puts the Registrar General on an equal footing with the DPP, the Solgen, and the Chief Parliamentary Counsel. So formally, the Registrar General was a member of staff of the Solicitor General. And I would wish to find out from the Honorable Attorney General whether there was any consultation with the Solicitor General on this move and the ramifications of such a move. Because when you compare the salary for the office holders who are deemed chief legal officers, and you look at the position now, you see there is a disparity of $3,230. When you look at where the groups, the Salary Reviews Commission, you have them in groups. So you have L1 for the chief office holders, and you have L2A and B. So between L1, which is the main office holders as it appears now, and when you look at L2, which is where the Registrar General is, there's, as I said, a disparity of $3,230. When you look at the office holders below that, you see that there is now, if we pass this legislation, there is going to be a disparity of $4,950. Now, I would also wish to find out if, from the Honorable Attorney General, whether there was consultation with the Salary Reviews Commission, the Chief Personnel Officer, on the ramifications of such a move. This has serious implications for other office holders in the judicial and legal service of more senior rank. So, and more important than whether or not there was consultation, I would wish the Attorney General to share with this Parliament the sage advice he would have been given from the Salary Review Commissioner, the CPO, in this matter. And if he did not follow that advice, I would wish him to explain to the Senate his reason for not doing so. Now, when we look at Clause 4, which seek to amend the Summary Courts Act to define video link, we see the same provision appearing also in Clause 35 as an amendment to the Administration of Justice Indictable Proceedings Act. So you have both amendments mentioning the person who are present at the proceedings. Now, there has been studies done in the UK on the whole effect of COVID-19 on video conferencing. So perhaps, the Attorney General could look at that as well, because one of the things it speaks about is one of the office holders here. So let me just go through. Who are going to be present at the proceedings? You have the judge, you have the master, you have the magistrate or magistracy registrar, and the clerk of the court. You have the parties to the proceedings. You have the attorneys at law acting in the proceedings. You have any interpreter or other person appointed to assist. And apparently there's been some problems in some jurisdiction with the interpreter being there. I see it as necessary because of all particular circumstances with the heavy presence of persons who do not speak English. Then you have any other person who may be required to assist the court in the conduct of its proceedings. Now, my question for the Honorable Attorney General, Madam President, is how rigid is the list of persons as enumerated in this clause? And I ask this because in certain matters, the applicant may wish some family member to be present to give psychological support. I remember years ago I was doing a property settlement. I was for the wife and she was being severely disadvantaged. The husband was there with his mother, who had sworn an affidavit in the proceedings. My client alone had sworn an affidavit, but she wanted her parent there, and it was refused. Well, eventually, she got what she wanted out of the Court of Appeal, but these things can raise some problems. And I want to refer to Domestic Violence Act 2007 of Ghana, where there's a provision in Section 13.1 which states, proceedings for a protection order shall be held in private in the presence of the parties, their lawyers, and any other person permitted by the court to be present. Again, in New Zealand Family Violence Act 2018, it says any person whom the judge permits to be present may attend a review of contact arrangements. And I would like to suggest an amendment, any other person whom the court permits to be present. So basically, those are the questions and remarks with regard to the legislation. But I just want to say that persons who work in the government service are frequently looked upon as persons who cannot do better. We have, like everywhere else, persons who are dedicated to their job as judicial officers, as persons working in the Registrar General's office, in persons working in Solgen and Chief State Solicitor and all of these other offices, who are extremely competent, who are extremely dedicated to their jobs. They have not had an easy time within the last few years when they have seen persons with whom they were forced to work making huge amounts of money when they themselves were stuck with a very small salary. And I would ask the Attorney General to look at this, because you have cases of somebody having to amend a one-page affidavit where another lawyer outside, a private attorney, is being paid $160,000, and the whole affidavit was no good. So it is very important that you think about the morale of staff who continue to serve and serve to the best of their ability, because they love what they do, and they have a commitment. They have a commitment to national service in that way. We do not want anything to happen. They've had it in the past, as you know, and I would hope that you would consider all of this very, very carefully. The office holders who are affected, because it is going to affect other office holders, is there anything that you can do for them as well? Because with all, you've spoken many times about the number of criminal courts that are coming on stream. That means the DPP is going to have a great, great responsibility. So one needs also to look and see whether, in truth and in fact, you can improve the office holders. Maybe there need to be wider consultation. I know you mean well, but we do not ever want it to be thought that we are creating legislation ad hominem. We are looking to see that the duties, and you've spoken about it, and you have said that, quite a lot has been done. You have said you are here to harmonize legislation across multiple platforms. And so it's not been a very difficult bill. I could breathe through it, but then perhaps what you could have said is that it's a consequential amendment. Make it simpler in language. Consequential amendments based on the fact that you've done a series of other acts, and therefore we have to harmonize them because you need to have things flowing. So look at the question of whether you are encroaching on the Salary Reviews Commission, which is something in the Constitution of the Republic of Trinidad and Tobago. If you're doing it in a roundabout way, look at that very carefully and see, in fact, whether you are doing it in the right way. So all in all, I think it was necessary that you're doing what you're doing in terms of harmonizing the legislation. But as I said, I have some concerns. Now, you mentioned that you've spoken to a number of persons about readiness, and perhaps what could have been done, like what was done for the Scotland Children Act many years ago when they introduced their new children legislation, that they had an implementation schedule. Had we done so with our Children Act as I had recommended, but I was ignored, we would not have had the problem of having to pay out a lot of money for claims being brought against us because we were not ready for XYZ. So perhaps what you and the staff can do is work out a whole implementation schedule and bring it to the Parliament. Make sure that when you put something in place, that you are ready to deal with it. And you do not have loopholes in the law for people to get rich off the taxpayers. So as I said, I hope that everybody will be considered, and it is not anything personal. It is for the good of the office holders across the board in your department and in your jurisdiction as Minister of Legal Affairs to do the best you can for every member of your staff. I thank you, Madam President.
Minister in the Ministry of Finance.
Madam President, I thank you for giving me the opportunity to speak on this bill. As the previous speakers have acknowledged, this bill covers several bits of legislation and is seeking to make amendments to those various bits of legislation. But, Madam President, I will focus my presentation on those areas that either directly impact or are directly impacted by the two hats that I wear as Minister of Public Administration, responsible for Information and Communication Technology, and Minister in the Ministry of Finance. Madam President, in that context, the clauses that I will focus on are the following. Clause 4, which introduces the definition of video link. a technological arrangement whereby a person, without being physically present in the place where the proceedings are conducted, is able to see, hear, and be seen and be heard by the judge, magistrates, parties to the proceedings, and other persons involved. Clause 4E, which provides for the holding of proceedings via video link. Clause 4L allows for fees and penalties to be collected by the clerk rather than the magistrate. Clause 4P, which says that payments may now be made electronically by the clerk to the controller of accounts. Clause 35, which allows for proceedings to be held, indictable proceedings to be held by video link. The original, the clause 4A dealt with the summary proceedings. And clause 37, which treats with electronic payments. Madam President, sometime last year, long before COVID-19 was an issue for us and the rest of the world, I had the pleasure to be at the launch of the court's e-service, suite of e-services. It was under the control of Master Maurice Allain, and I was pleasantly surprised at the range of services that the courts were launching on this e-platform. It gave a clear indication of where we were heading and what the future of the court operation would be. In comes COVID, and we come to the realization that this e-platform, this e-approach to court operations and management and filing is no longer a wave of the future, but it is now. We are forced to expedite and bring forward implementation of this range of services that we were in the process of introducing. E-payments, we had a debate sometime last year to introduce the concept of e-payments into the court, so we have already started working on that. But this bill seeks to allow, among other things, the fees and payments collected by the court to be transferred electronically to the controller of customs, controller of accounts. This allows for greater efficiency of transfer of funds. It allows for better recording and better tracking of payments, which is always a good thing. It makes it easier for the members of the public who are making payments to make the payments remotely, to do so without having to go to the district where the offense was created or the matter was heard. And so it just makes life easier. And I see no reason, Madam President, to have any concerns with respect to this particular provision. Moving towards e-courts and virtual hearings, this is something that the world has been on board with for quite some time. Trinidad and Tobago is a bit behind the ball, but as I said, this is something that the courts were preparing for, fortunately, before COVID hit. So when COVID became a reality for us and we were forced to go into lockdown to protect the lives of and health of the citizens, it was not necessary to cease the operations of the court. We were able to efficiently and effectively continue with those operations and hear hundreds of cases during the period of the lockdown, despite the fact that we were not allowed to physically congregate in more than groups of 5 originally, growing now to 25. So the courts have continued to operate, we have continued to operate, and the measures in the bill that seek to give effect to the e-hearing process is going to allow us in future to continue on that trend. Now, there are several benefits arising out of introducing an e-court system, a virtual hearing system. One of those benefits, I can say, as Minister of Public Admin as well, responsible for real estate owned and leased by the government, is that it will allow us to reduce our physical footprint. We will no longer in future need the space that we need now, a lot of it very expensive space, to store physical records, because we will be receiving our records more and more in virtual form, which reduces the need for the storage of paper. It has, as the AG has pointed out to us on several occasions, it has allowed us to reduce the movement of prisoners, which is not only an expensive exercise in terms of money costs to the state, but it is also expensive in the inconvenience that it causes to all of us as citizens traversing these areas where the prisoners have to attend court. So on several Fridays or other days when we are trying to get to Parliament or offices, we have had to suffer the inconvenience of roadblocks, of traffic, because we have a significant criminal case going on and the roads have had to be blocked, there are policemen and so on. Moving to a virtual space where the matters can be heard either on the compound of the court or virtually, we move away from those inconveniences. The introduction of virtual hearings is convenient for attorneys. At the moment, an attorney who has a matter in Tobago may only be able to deal with that matter on that day. And what does that cause? It causes the attorney to become less efficient because he has to travel to and from Tobago, he has to deal with that matter, and therefore he cannot get to another court in Trinidad, for example, to deal with another matter. Virtual hearing will allow an attorney to more efficiently treat with the range of matters before them, and therefore hopefully improve the speed and efficiency of justice. This leads to a situation, or it should lead to a situation, where a client's matter is more efficiently handled because, as I said, the attorneys can deal with more. There is a reduction in the length of time it will take to deal with the matter, and therefore, hopefully, justice becomes more affordable to those of us who are challenged now to cover the cost of attorneys and other representatives. So, Madam President, with the introduction of e-filing, it is anticipated that the system of justice will become more efficient, and that it will create greater access to all citizens to have their matters heard expeditiously, and heard in a way that they can afford. E-government, e-transactions, e-payments have, in the not too distant past, been viewed as the wave of the future, something that Trinidad and Tobago needed to move towards. With COVID, Madam President, it is no longer the wave of the future. It is a present and pressing imperative for now. We cannot operate outside of the e-space because we don't know how much longer COVID will be with us. We don't know. If we look at countries around the world, we see that there are reopenings and then contractions of those reopenings to deal with more cases developing and so on. And so for an indefinite period going forward, we will have physical constraints on our movements and our operations and how we do business. And we cannot continue to operate in the absence of an e-platform. So that is a present requirement. The judiciary, paradoxically, despite the fact that it is an institution that has been constantly under attack for the inefficient dispensation of justice, is leading the charge in the transformation to the e-transaction and e-operating space. if we look at all the organizations or institutions that form the government of Trinidad and Tobago, the judiciary is the most advanced in the e-space. It has an e-filing system, a virtual hearing system, and can track and conduct its business largely on an e-platform. It has made great strides in this area. And Madam President, in that context, I would like to commend the Chief Justice and his team for leading this charge long before we realized that COVID was going to become a reality. Led under the leadership and direct guidance of Master Maurice Allen, who has done a very commendable job. The judiciary has taken us forward into the 21st century in this e-space. This bill seeks to support the actions they have already taken and continue to develop on. Now, I acknowledge that there are challenges remaining in the rollout of the technology, and a lot of that is probably caused by the fact that COVID was in fact unexpected and we needed to do a more advanced launch than we would have anticipated. So there have been teething issues, there have been equipment shortages and other such challenges. But these issues are being addressed, and as we move forward, as we learn from the mistakes, as we deal with the shortages, as we allocate more funds to the area, we will see the system working better and smoother and hopefully benefiting all, with the objective that in the not-too-distant future, justice will be much more efficient and much more affordable, and therefore more evenly benefit everyone in society. Madam President, another area that I would like to focus on is the provision in the legislation, and I will tell you in a minute what clause it is. Clause 27 of the bill, which deals with the value-added tax, amendment to the value-added tax section 47A. Madam President, as everyone in this chamber will recall, we recently introduced this amendment of section 47A to allow for the settlement of VAT refunds through the issue of bonds rather than cash. And that exercise has started and is going very well. What this amendment in today's bill is seeking to do is allow us to the option of issuing bonds in future as taxable or non-taxable. And when we talk about taxable and non-taxable, we're talking about the interest that the government will have to pay on the bonds that will either be taxable or non-taxable. What that does is that it gives the government of the country the option in future to control the cost of the interest that they will have to pay on these bonds, because they can give the same benefit to the recipient of the bond or the person to whom the bond is transferred by paying, for example, 4% on a bond, the interest on which is taxable at 25%, or 3% on a bond, the interest of which is non-taxable. And so it gives the government some leeway in structuring these bonds, controlling the cost, controlling the outlay that it will have to incur either now through the reduction in taxable income or in the future through the payment of interest. And so that is all this provision is intended to do, to give the government more flexibility.
Minister, you have 5 more minutes.
Thank you, Madam President. To give the government more flexibility in terms of how it structures the bonds. Madam President, in wrapping up, what I would say is that although COVID-19 has been traumatic and continues to be traumatic, it has given us the opportunity to do things differently, to do things better. The judiciary is leading the charge, as I said, in getting us to a place where we do things better. I see a world becoming a reality where justice is more efficient, it's more affordable, and it benefits the society as a whole. These provisions, Madam President, seek to facilitate the movement in that direction. And I highly recommend these provisions in particular and the bill on the whole to my colleagues in the department. I ask you for the support because there is nothing in these provisions that can be regarded as negative. It's all in an attempt to make us more efficient, to get us where we need to be as a society. The judiciary, as I said, is leading the way. The government is intended to follow in getting on the e-business, on the e-transaction platform. So, Madam President, I fully endorse the AG's piloting of this bill, and I seek the support of my colleagues. I thank you.
Senator Sobers.
Thank you, Madam President, for recognizing me this morning to contribute, this afternoon rather, to contribute on this miscellaneous provisions bill. A title too long to recite at this juncture. I suspect that others may indulge in so doing. I won't. But it is a very lengthy miscellaneous provision, the majority of which is simply copying and pasting, taking out certain words, amending in very minor places within the bill itself. But I would focus specifically on about 3 or 4 clauses, just to make some light comments in terms of my review of what I saw, that maybe in wrapping up or even in the committee stage we can have more fruitful discussion. Now, the first clause which I looked at was clause 4, which sought to amend the Summary Courts Act, Chapter 420. And basically it gives power to the Chief Justice to appoint varying locations for the holding of summary courts and designated court location for the hearing of specific types of cases by a summary court. Now, when I read the clause, the first thing that came into my mind, I would recall being a child, not more than 2 years at the point in time, but I recall when the coup took place in Trinidad, that the court system, or where the trial for the offenders during that particular period of time took place, was at Chaguaramas. And one of the reasons for that is because obviously at that juncture we could not, in best practice, secure persons attending the matter at the Magistrates Court in Port of Spain. And so I do in fact see some degree of wisdom in allowing for situations like that to occur. I think the good Minister West indicated as well too that we as well, when we come to Port of Spain, we experience significant traffic delays based upon a particular matter or matters that may be ongoing at the Port of Spain Magistrates Court. Certain measures are adopted to ensure that persons who attend the court and persons within the very near location to the court are not affected in a negative or criminal way. My only thing, when I looked at it, I think especially for the proponents within the system, the individuals who may be affected, that at least some degree of consent possibly should have been requested from them if the court matter were to be moved. I don't see, respectfully, any attempt or any possibility, in my humble opinion, that would affect the administration of justice if the court itself, the physical location, is moved to a more secure location. The proper reasons are advanced before that actual move takes place. But I think sufficient notice and possible consent with the persons within the matter, the accused, his attorney, and whoever else is concerned and directly connected and affected to the matter, that they should also be consulted with before that actual move takes place. Now, and one of the reasons for that, the new location as well too, we should ensure, even if it's a situation where possibly the accused may not be physically present within the room, it isn't a foreign concept. In civil matters, it has occurred in arbitration matters where expert witnesses have to give evidence. In some instances, they live in foreign jurisdictions. So evidence is taken from them via audio, visual recordings, and systems. But in some instances, if the connection is not good, it is difficult for a person who may very well be asking questions of the witness to glean from that particular witness certain responses in terms of body language, or even in terms of just normal audio responses, because the system is lacking. So we should also ensure that those systems, the infrastructure for such a situation is up to standard. I have been told so far, in terms of the audiovisual systems that we have now taking place with most courtrooms, it has been working well. It's a shame that we had to wait for the advent of something as terrible as COVID-19, that pandemic, for us to reach to this position where we have to embrace this type of technology. I'm told many practitioners enjoy it. Some of them do so wearing their shirt and their tie and their jackets, and in some instances, no pants. That is what I'm told, right? But they're enjoying it, you know. I wear pants. But I just think that there should be some degree of consultation with persons involved in the system, and we should ensure that the infrastructure is properly in place to facilitate such a venture before we get into that. Now, I particularly looked at Clause 14, and Clause 14 deals with this situation where we intend to amend the Defense Act. Right? And basically, it's to introduce this whole concept of interdiction. And for members of the listening and viewing public, and even for the benefit of persons in this chamber, interdiction is simply a situation where a person would not, in the army, for instance, who holds a particular rank, will not be able to benefit from all that the rank would afford him if he was in full commission then. So he may not be able to benefit from the level of pay or emoluments. He may not be able to benefit from getting a driver and whatever else goes along with the rank. And when I read it, I initially found no objection. And to an extent, I still don't find much of an objection with respect to this particular amendment. I mean, a lot of us who operate in varying professions throughout this country, we tend to complain when certain infractions occur in alternative professions, and we do not see any justice, in our opinion, or any significant action being taken against an individual involved in an infraction. And we complain and we indicate all sorts of things sometimes, that they operate in a clandestine manner. We do not know what is taking place there. People say that about lawyers all the time. Lawyers, I shouldn't say lawyers. Some individuals say it about doctors, and so on and so on and so on as the wheel turns. And for some time, both the defense force and even sometimes with respect to the police service, persons would have made certain comments. The police service, fortunately, has gone through significant stages of evolution, and there's a high degree of transparency, in my humble opinion, with respect to a lot of things that take place. We have the advent of the Police Complaints Authority, you have the Professional Standards Bureau, you have police disciplinary proceedings internally. So there's a significant degree of transparency afforded to the police service. But in terms of the defense force, I would want to say that we don't see the same situation occurring there. And from my discussions with certain members of the Defense Force, they've indicated that there's a particular reason for that, insofar as they are governed by military law. And I had a very lengthy discussion with an individual concerning that, about this opaque cloud that surrounds the Defense Force, and what is military law, and what does it entail, and who practices there. And because we don't know. I mean, I can't recall picking up any local newspaper within the last couple of years and seeing any transcript or word-for-word play as to what took place in a disciplinary proceeding in the military, or whether or not any disciplinary proceeding has taken place within the military within the last couple of years. And I was told that the reason for this is because some of their operations tend to take them outside of the zone of normal legal jurisdiction. For example, if there's a visiting forces agreement where some of our military may go to Haiti to assist in peacekeeping, and one of the officers, servicemen, gets into some type of illegal situation across there. When the serviceman comes back here, he is not subject to the Trinidad and Tobago justice system in terms of the courts. The visiting forces agreement would specify that he would be treated with accordingly through the military. And so I think because of this cloud of opaque activity, I thought as a civilian reading about a simple interdiction situation that it would have been sufficient. But I am told, and I had some discussions with the Honorable Attorney General, and I am certain in his wrapping up he would address them. I am told by some members of the military that there are systems in place already that can properly treat with this situation, but for the fact that there is not sufficient infrastructure in place. And when I inquired what that infrastructure was, the individual indicated that there was insufficient judge advocates that aren't available to them, that there are insufficient advocates who are familiar with military law in Trinidad and Tobago. And based upon that, you have a very slow pace with respect to military justice being administered to offending officers. So hopefully when the Honorable Attorney General is winding up, he can address what measures or steps may have been adopted during this administration's tenure to fix or solve those issues within the organization, as well as what may very well be the complement of any judge advocates that may have been hired, how many matters have been held or dealt with during that particular period of time, what is the complement of qualified persons who may very well be able to assist in terms of advocating these matters within the military as well too. And generally, what is the infrastructural needs for the military when it comes to court-martialing and whatnot. And I think that would definitely help both the members of the public and also members of the military who are hearing about this introduction for the first time. And it may bring some comfort to them, because some of them liken this particular introduction situation to that of the zero-tolerance policy, which I think, as the Attorney General pointed out, it is fundamentally different. As in the zero-tolerance policy, there was no real due process. This particular amendment demonstrates some degree of due process. But I still think it would be beneficial to those listening and viewing if some level of discussion could be had so that their hearts could be put at ease with respect to this particular situation. Now, moving on, I also looked at Clause 26, which sought to increase some of the fines and penalties under the Wildlife Act. And I think for some time now, we as a nation have had a lot of persons within the country crying out for an increase in those penalties. And rightly so, in terms of where these penalties are now going to be administered for persons illegally entering game sanctuaries and state lands and hunting during the closed season. It is extremely important for persons to understand why these sanctuaries are set up in such a particular way. to allow our wildlife to continue to exist, especially in that moratorium period when hunting is closed. So definitely for persons taking advantage of that, there should be some type of penalty now running concurrent with such illegal activity. And I think the increase in the penalties are much needed. I would also possibly like to hear maybe if the Minister of Agriculture is contributing today, he can indicate also what other systems, strengthening of the institutions itself with respect to game wardens and other individuals who would be policing such terrain. What other measures have been adopted by the Ministry of Agriculture during their tenure to assist persons to enforce, because it's fine that we pass legislation here in this House, but we need to have persons out there with the ability to enforce, with the understanding of what they are doing, and the proper infrastructure being put in place. Clause 30 to 34, the different changes in the licensing committees. I mean, from time to time, we've heard about those changes taking place. It's good that we're seeing it now manifested in legislation. I know in terms of the composition of the committees, they actually changed for some time now. And it has been auguring.
Senator Sobers, you have 5 more minutes.
Yes, please, Madam President. And it has been auguring pretty well, I think, in terms of the secretary and the chairperson now being there, as opposed to the magistrate. It would allow the magistrate to continue to do their own work. And the committees are being run at a quicker pace now, with hearings being dealt with much faster. So that, the bill, as many have said already, it's quite voluminous, yes, but, the majority of the bill really just treats with certain small changes here and there, which are needed, I suppose, with respect to strengthening certain pieces of legislation that we have worked together as a Senate to produce. But I would really like to hear from the Honorable Attorney General with respect to those issues, specifically with respect to the Defense Force, and even addressing that little situation, possibly with consultation when we are moving certain hearings from certain places. With those few words, thank you very much, Madam President.
Senator Hussain.
Thank you very much, Madam President, for giving me the opportunity to join in this debate an omnibus piece of legislation which seeks to amend 35 pieces of legislation in one second reading in this Senate. And Madam President, we know that the end is near in terms of the life of this 11th Parliament. The end is near, and the government has to tighten up some of these administrative issues with regards to these pieces of legislation. But while time is of the essence, we must also understand that we are interfering with the judicial process and the manner in which the judiciary functions and operates, especially in light of a pandemic of COVID-19. And we have seen that some persons may have been not allowed access to the courts for some time because of the pandemic and the closures therein. But action has been taken in terms of having hearings being done virtually. And, Madam President, this bill, in its present form, seeks to also put things in place in terms of the summary jurisdiction. Because you will well understand that you have the High Court jurisdiction and you have the Magistrates Court jurisdiction or the summary jurisdiction. And this bill amends the Summary Courts Act, Chapter 420. And the Summary Courts Act acts as that parent piece of legislation that creates the Magistrate Court and the magistrates. And this is important because a magistrate's jurisdiction is only extensive to what is given to him by written law. A magistrate finds himself as a creature of statute under the Summary Courts Act. And what I read and what I understood from the amendments by Clause 4 of the bill would be that you are going to attempt to increase the efficiency of the magistracy through virtual hearings and also the delimitation of boundaries per se when it comes to the magistrate's jurisdiction, the physical jurisdiction that is. Because, Madam President, you would understand that Trinidad and Tobago is divided into several magisterial districts, and there are various courts in each district that deals with matters that may have arose. So if an offense, for example, happens in a particular district, for example, Port of Spain, that particular complaint or information will be filed in that jurisdiction. Now, this bill seeks to make it a bit more efficient in terms of if a matter arose from one particular jurisdiction, it may be heard in another jurisdiction. And that is one of the first issues I would like to raise. Because when you look at page 5 and 6 of the present bill, you would see at the amendment to Section 7 of the Parent Act, sub 3, where the Chief Justice considers that having regard to all of the circumstances, it is desirable to do so in the interest of securing the most expeditious hearing and determination of any case or type of case. The Chief Justice may transfer proceedings in a summary court from one court location to another court location. So, Madam President, what this Parliament is empowering the Chief Justice to do and the government's policy is that the only consideration for a case to be transferred by the Chief Justice in the summary jurisdiction is whether or not it's expeditious to do so. Now, Madam President, there must be some more consideration. It cannot be that expedition is the only factor that should be involved when you are going to transfer a matter. There must be other things that should be considered. When you look at the civil proceedings rules, there are other factors in which matters will be transferred based on an application being made to a High Court judge. Now, I saw that this factor that the Chief Justice considers of expeditious hearing is also found at page 5 of the bill and also at page 6, sorry. So, Madam President, what I'm saying is that you cannot at all times just use this as a consideration, because in Trinidad and Tobago, you would understand that there are various interests in society. And, Madam President, I'm casting no aspersions on anyone, but we have to face the reality that this can lead to some level of forum shopping. And this is something that should not be happening, because in the Constitution, you're guaranteed to a fair hearing. And in this case, if, for example, any person who holds that office of Chief Justice, he will now be able, maybe, by transferring a case to influence the outcome of a particular matter.
Saying, I really don't think you should be saying that. I think you are infringing on the standing orders.
Yes.
So I'd ask you to withdraw it. Try and present your arguments a different way.
Sure. Madam President, I cast no aspersions, and I do withdraw that statement. In what I'm trying to say is that any office holder, in fact, because you are looking at a judicial officer who holds a lesser office than the Chief Justice, who's a magistrate. And you want to ensure, Madam President, that no influence or no pressure is being placed on these judicial officers who are considered as magistrates to decide any particular matter one way or the other. And that is the point that I'm making in this particular legislation. Also, Madam President, you would see at page 8 of the bill, which continues with the amendment to the Summary Courts Act, it deals with the transferring of cases again by the Chief Justice in certain circumstances. And this amends section 13A of the bill. And if you would allow me, Madam President, at 13A of the Act, it deals with the Director of Public Prosecutions under cases that falls under the Dangerous Drugs Act. the Director of Public Prosecutions can, in fact, request to the court that the case be transferred based on expedition also. So at that particular provision, what I am saying here, Madam President, is you are giving the Chief Justice an additional power. Because originally at Section 13A, it's the Director of Public Prosecutions who makes the application in matters of dangerous drugs to transfer matters from one jurisdiction to another within the magistracy. In this case, you are giving the Chief Justice the power to transfer any case to any jurisdiction within Trinidad and Tobago. And the point is that when you look at Section 56 of the Act, Section 56, where we are going to amend also, it talks about a different factor that the court considers. And that factor is, Madam President, in the interest of justice. So there's a bit of inconsistency within the bill. Because at Section 56, when you're looking at the transferring of matters, you look at the interest of justice. But in the others, you're looking at the expedition of the case. And that is something that I asked the Attorney General if he can give some clarification on in terms of whether or not we can apply some consistency going forward with respect to the factors that the court or the Chief Justice can take into consideration before a matter is actually transferred. Now, another very important issue I think we need to realize here is the amendment to the Petty Civil Courts Act. Madam President, if you would allow me, the Petty Civil Courts Act now has jurisdiction, which are magistrates who sit in a civil capacity because they wear different hats. And the magistrate sits in a civil capacity to determine matters of a civil nature. And they can determine cases up to $50,000, $50,000. Madam President, would you know that sometimes a person has to wait almost 6 to 8 months for one case management hearing in the Petty Civil Courts? Madam President, this particular court deals with persons who may have conducted businesses, offered services for under $50,000, and they have to go to court to get some level of remedy, and therefore these persons have to wait so long. So there must be something done in order to treat with the inefficiencies in the system when it comes to the Petty Civil Courts. Because in the High Court, you would understand that cases flow a bit faster, that cases, because of the civil proceedings rules, flow a bit faster, that most matters are settled, in fact. But in the Petty Civil Court per se, where most of the persons who are small contractors, small businessmen, go to that court to enforce a contract at disadvantage because, one, your claim falls under $50,000, and two, the system is bad. So those are the issues that the small man on the streets face with regards to these matters. Now, Madam President, I hope that when this bill is passed, because the government has the inbuilt majority in the other place, and if they get the support of this House, Madam President, that this really helps the people of Trinidad and Tobago access justice. And they must access justice at both levels, at the civil side of the magistrate's court and the criminal side of the magistrate's court. The system has to work, because at the end of the day, we cannot continue to do the same thing over and over and expect a different result. These virtual hearings can, in fact, cause some level of efficiency. But, Madam President, we must not look at expedience to trump true justice. Because I can tell you for a fact, Senator Sean Sobers raised it a bit earlier, that some persons, in fact, prefer cases to be heard in person. And I would say that because when you look at a criminal trial per se, one of the most important things that you do in a courtroom is to examine the demeanor of a witness. And during a virtual hearing, that is something that you may not be able to properly examine to determine whether or not the witness is a witness of truth or whether or not the witness is being untruthful. So those are things that we have to consider. I know that may fall within the jurisdiction of the judicial officer in terms of his case management power, whether or not those trials should be held in person or whether it should be held virtually. Now, Madam President, while this bill comes at this late stage, who knows, this may be very well our last sitting in this Parliament. And I want to say, Madam President, that you can bring 35 amendments in one bill, you could bring 100, you could bring 200. When we go to the polls, Madam President, the United National Congress will form the next government of Trinidad and Tobago. Because for far too long, Madam President, they had 5 years. They promised the persons for 5 years, and they did not deliver. We are saying on this side, Madam President, that we will work for the people of Trinidad and Tobago, and we will get Trinidad and Tobago working again. And through you, I look forward to meeting my friend, Senator Williams, on the campaign trail. And I thank you very much, Madam President.
Senator Dana Ryan.
Thank you, Madam President, for the opportunity to contribute to the debate on this Miscellaneous Amendment Bill number 2, 2020. Today, my contribution would be very short and would focus primarily on Clause 27 of the bill, which treats with the amendment to the Value-Added Tax Act. Now, 47A, the amendment actually amends Sections 47A, and this section was introduced into the Value-Added Tax Act earlier on in this year on the onset of pandemic restrictions. So this was introduced to allow for the Board of Inland Revenue to meet the tax liability through the issue of the VAT bonds. And in issuing these VAT bonds, we will issuing VAT bonds that are interest or non-interest bearing, and also bonds that are transferable or non-transferable. So this amendment includes an addition to allow for these bonds to be taxable or non-taxable. The Attorney General and the Minister in the Ministry of Finance actually alluded to the fact that on the initial issue of the bonds, the VAT bonds, worth $3 billion, it would be tax exempt. That is, the interest incurred on holding these bonds would be free of interest. But on examination of the regulations that was laid in this Honorable House, Madam President, it was laid in May of this year, and the regulations prescribes that the bonds are actually going to be transferable, and it's going to be transferable to financial institutions with the exception of credit unions. So my question is, Madam President, is would the tax exemption alluded to by the Attorney General and the Minister in the Ministry of Finance apply to all holders of the bond? Now, I know the details would probably be prescribed further in the regulations again, because there would probably have to be another amendment to the regulations. But it is important to know whether the VAT bonds would continue to be non-taxable when it changes the hands of the initial bondholder. And not only for this issue of the initial $3 billion of worth of VAT bonds, but also for any subsequent issues, given that the Section 47A allows for up to $6 billion to be issued in VAT bonds. By amending the law to say that these bonds are taxable or non-taxable, it also leaves room for future issues of the bond to be taxable. And this, to me, sounds a little bit inequitable, especially when these bonds are being issued at par value and rather than at a discounted value to persons who would have been owed tax liability. How I figured it would have worked, Madam President, is that the initial holders would have been exempted from tax from taxes on the interest of the bonds. And then when it would be transferred to financial institutions, the bond becomes taxable as these persons are not owed any tax liability. Because when these bonds are transferred to financial institutions, with the exception of credit unions, they are now going to be traded on the secondary market, where it is now traded solely to generate income and as a source of return on investment. Financial institutions at this point could strip the bonds and trade them at this point. The purchasers of these bonds on the secondary market would not be persons who are owed any tax liability. So there is an opportunity to tax the bonds at that point in time. However, the initial holders, the initial bond holders of the VAT bonds should not be taxable either at this point or any future issues of the VAT bonds. So whichever case it may be, right now or subsequently, I just seek clarification, and maybe it could be explicitly stated in the law. Now, before I wrap up, Madam President, there are 3 key things that I want to mention with respect to the same clause 27. And I want to caution the government in the sense that this bond would be due in 2023. And the government will need to repay this principal in 2023, a total of $3 billion, which accounts for 2% of GDP. But interestingly, Madam President, just in the recent reading of the midterm review of the budget, the minister did indicate that in 2023, they are also setting a target to reduce the debt to GDP ratio to around to pre-pandemic levels at around 63%, which is a reduction in the debt to GDP ratio of approximately 10 percentage points. That is moving the net public sector debt from $111 billion to $103 billion, according to latest central bank figures. I just want to remind the government that these monies to repay this bond in 2023 must be put aside within the next year to ensure that this bond is repaid. And because the last thing that we want, Madam President, because obviously, yes, the government will repay the bond, but the last thing we want is that this target of reducing the debt to GDP ratio to 63% becomes a moving target, just like how the target to balance the budget has been a moving target for almost the past 10 fiscal years. Another thing that I would like to mention, Madam President, is that we have to ensure that a situation like this does not happen again. It doesn't repeat itself. It is not fair and equitable to have businesses being owed these tax liabilities and no interest is being accrued. Now, I know there's an interest being accrued on the bond at 3.3%. However, this 3.3% would be accrued going forward in the 3 years going forward, and at this point in time, they are being issued at par value and not at a discounting value. Right now, the law is stated in such a way that the method of reimbursement of tax liabilities would be chosen by the Board of Inland Revenue or the minister in this case. And what I'm saying is that we could make some provision to allow for the taxpayer, the businesses who are filing these VAT returns, to choose an option as to whether they would like to be reimbursed via cash or via VAT bonds. It shouldn't be entirely up to the government only. Now, the government always, in some sense, over the past couple years, fiscal years, has been strapped for cash, even before COVID-19 pandemic. There has been a large amount of VAT returns every year versus the amounts of revenues that comes in on a quarterly basis that are meant to meet these VAT obligations. So going forward, instead of having to build up over a period of time, maybe we could really just give these taxpayers an option, a cash option and a bond option. Smaller businesses would benefit from this in the sense that, yes, they would most likely require a refund of a smaller amount, but however, are the ones who would need the cash liquidity in their businesses faster or much more than the larger businesses who could probably have opt for 25% in cash or 75% in VAT bonds. So what I would do, Madam President, is that it would allow us to develop a system that benefits everyone. You're getting a higher rate return on an initial investment. You also have a situation where the government also would receive cash on a regular basis. And we should probably take into consideration making provision of this in the law going forward. The last thing that I want to mention, Madam President, is that in making sure that this situation does not repeat itself, some way or the other, we need to make some provision to introduce a time limit and a penalty that would be built into the law that holds the state or the Board of Inland Revenue responsible for late reimbursement of taxes to businesses. Just like interest is accrued to businesses and individuals when we pay taxes late, in the same way, VAT returns, the government should be reimbursing. Once they are late, they should be reimbursing with some sort of interest. With those few words, Madam President, I would like to thank you.
Minister of Trade and Industry.
Thank you very much, Madam President. Caught me a little off guard there. Thank you, Senator Mark. Time to breathe. You're going to have a lot of time to breathe coming up soon. Okay? Let's go into the bill. Again, we're here because we are seeking to make amendments to 35 pieces of legislation. I'll comment just on a few. But again, generally, these amendments will seek to tighten and to improve and to make right and to fix several pieces of legislation. Some of it is quite straightforward. Some of it really seeks to modernize the legislation. And it is those few that seek to modernize and improve legislation to the point where we're speaking about technology improvements. I would touch on, I would speak to those. So, Madam President, I go straight into Clause 17 of the bill, which seeks to amend Clauses 7, 8, and 9 of the Registrar General Act. Now, the AG would have spoken to it fleetingly, and I just want to expand a little bit on it. So, the amendment for Section 7 will now make provisions for electronic payments for services rendered by the Registrar General. Let me say that the Registrar General's Department oversees civil, land, and commercial registration in Trinidad and Tobago, and it maintains the National Archive of Births and Adoptions, Marriages, and Deaths from time immemorial. It also records land titles and maintains a register of companies and businesses, and therefore this kind of amendment will now allow for electronic payments for any of all of these services mentioned above. And of course, what this does, it is actually makes it a lot easier and efficient, allowing for saving time for many of the homeowners and other and citizens and businesses in general who will seek to access any of these documents. It just makes it so much more convenient and less time-consuming. Clause 17 also seeks to repeal Section 8 of the Act and put a new section which requires the Registrar General to keep a true account in electronic or other form of all fees received and the names of the persons, the services, the dates, the transactions that occurred, and so on. At the end of the month, the Registrar General must certify and correct a transcript of the accounts for the month. The amendment to 9.1 seeks to expand the days in which the Registrar General will not be conducting business to the public. And currently the opening hours are Monday to Friday, 8:30 to 3 p.m., except Saturdays, Sundays, and public holidays. And the new section keeps the same opening hours, but expands the exceptions to Saturday and Sundays, to the exceptions of Saturdays and Sundays, pretty much what exists now, but it puts it into law. Carnival, Monday and Tuesday, public holidays, and so on. The next working day after Christmas Day, Monday and Tuesday after Easter, and any other day as the Legal Affairs Minister may direct. Again, this is just about tidying the legislation and getting it right. Again, as we speak about the entire matter of electronic payments, Madam President, which is all about Clause 17, these e-payments are really very, very needed. And these are really what we refer to as the payment for goods and services via the internet. And it includes financial transactions using electronic devices like your computers or your phones or your tablets. And all of these can be used using your credit and debit cards and bank transfers and so on. Again, all of this is very user-friendly, and it secures the online interface between business and for businesses and individuals. And this is just amplifies what is already in use in terms of, for example, the TT BizLink, which is our when I say our business, but it is the single electronic platform for business and business services. So the inclusion of the electronic payment at the Register General, again, is a very important step, as I wish to emphasize once again: quick, convenient, efficient. And it means that you can apply online and pay for your, you certainly pay for your birth and death and marriage certificates online, and that no need to go into the Ministry of the Attorney General and Legal Affairs Office. And I think the service is very efficient as it is now. You can actually, all of the documents are delivered straight to your home via TT Post. You may also know, may or may not know, Madam President, that the Property and Investment Management System, Land Registry at the and also the land registry at the Register General's Department can now be accessed online. And this project was completed and allows one to search the digitized land registry records for information on land title documents, deeds and bills of sales and judgments, and lease pendants and deed polls and so on. So again, we want to commend somebody. I heard somebody commending a lot this morning the judiciary for the work that they've been doing, and I want to see that we want to commend our Honourable AG and his staff at his ministry for making all of these services available to the public. Again, ensuring that we have some seamless transactions and very user-friendly, again, transactions. So I want to go directly to, as we're talking about e-payments and so on, I want to go to Clause 21, which has to do with electronic signatures. And as Clause 21 of the bill seeks to amend Section 32 of the Electronic Transactions Act to remove the word accredited and substitute the words as provided for in regulations established. So that this section will now, the new section will now read that an electronic signature that is associated with an electronic authentication product issued by an electronic authentication service provider as provided for in regulations established under Part 5, hereinafter referred to as a qualified electronic authentication product, is deemed to satisfy the requirements set out in Section 31 for reliability and integrity. And you may ask, what does reliability and integrity mean? And the criteria set out for reliability and integrity pertaining to all of these electronic signatures are as follows. The A, where the authentication technology uniquely links the user to the signature. B, the signature is capable of identifying the user. C, the signature is created using a means that can be maintained under the sole control of the user. And D, where the signature will be linked to the information to which it relates in such a manner that any subsequent change in the information is detectable and given certainty. And E, such other criteria as may be prescribed by the regulations. So this electronic authentication product means a product designed to identify the holder of an electronic signature to another person. And again, giving certainty to the entire transaction using the electronic signature. The clause also seeks to amend Section 33 of the Electronic Transactions Act by removing the word qualified from the electronic authentication product. And this section requires that any person who wishes to use an electronic authentication product for the public must be registered as an electronic authentication service provider by a designated authority on order of the minister. And these amendments will all further facilitate and support the ongoing digital transformation projects across government to improve the general ease of doing business. And certainly it was a great help during COVID. Minister in the Ministry of Finance, Minister of Public Administration spoke about that. The ability to use, I can tell you from the Ministry of Trade, I worked from home and I used the electronic signature for all of my correspondence and so on. And very widely we used a number of electronic services to take us through as a cabinet and as ministries through the period. I just want to go to speak a little bit about clause 29, which clause 29 of the bill, which seeks to amend section 492 of the Companies Act by extending the period in which the registrar may hold a name for a company from 20 to 45 days upon request and the payment of prescribed fees. I just raised this, again, because it applies to business as well. This extension really affords companies, whether they're new or they changing ownership and name and so on, but it gives you the time to get all the paperwork together and all the necessary requirements that will be required to be put in place. I go straight to clause 28, and we speak always about diversification of the economy, and this clause 28 relates directly to the yachting industry, and in particular, I can go to...
Minister, you have 5 more minutes.
Yes, sorry. Thank you. Yeah, relates directly to the yachting industry. And I go up particularly to section 264, which would, I go particularly to that part, because I'm not sure, but I think it's section 264, which empowers the minister by order to prescribe forms required to be used for customs laws and so on, removing the authority from the controller. And I want to talk in particular about the situation with the yachting industry. We've always not been able quite to get the kind of business. At one point we had it, but we lost the business to St. Lucia and Grenada, largely because those are very, very attractive places, destinations. So largely the yachties are attracted to going there. But also because our whole process of admitting yachties into the country was very complicated, so that you required the filling of some 13 forms. And what we're suggesting now is that we're going to be going with one form. I know that it is almost ready. All of the agencies involved, including Ministry of Agriculture, Ministry of Health, Customs and Excise Division, and the Ministry of Finance, anybody who has anything to do, including addressing matters of firearms and so on, anybody having any ministry or agency having anything to do with it has been meeting with the Attorney General's office and in preparation so that we can have this one form which would be used for yachties once coming into Trinidad and Tobago. And that is what we need. We keep talking about ease of doing business, and all of these elements are included under that. This is an industry that can grow. It's unfortunate that COVID has denied Delta Sub Blow and denied the entry of yachties into Trinidad and Tobago. After all, we've been looking after our nationals more than ever. But we are committed to this industry, and therefore I'm sure within the passage of time, you would see that we would probably move to getting this industry going again. As I said, and the AG would have announced it too, we are below the hurricane belt. We have a number of skilled craftsmen, and that's the advantage we have as against the Grenada and St. Lucia. And these people are very skilled in repairing these yachts and boats and so on. And we want to make sure that we can create an entire ecosystem. The ecosystem exists as it is with all the hotels in the northwestern part of the country, the peninsula. But I mean, all of these craftsmen are part of the ecosystem, and we want to make sure that this is going. Madam President, I have very little time, but I just look forward to us having this fully cashless society, having benefits in terms of reducing cash handling and increasing the speed at which we do business, increasing, of course, and when you do that, the ultimate thing is that we're able to increase our taxes and our tax collections as well. We're looking forward to this age of full digitization of our economy, and it will certainly pay huge benefits to us all. And as I said, what we do in the Ministry of Trade and Industry through the TT BizLink, it's a building block towards this entire thriving digital economy. We're looking forward to greater online payments, the opening up of more of greater e-commerce, especially for the small businesses themselves, where they're able to take their businesses to another level, regardless of size. I mean, the future of technology is great for us, and we look forward to this entire process system as it seeks to improve all industries, including agriculture, manufacturing, and so on. It's all about scale and becoming competitive and so on. So, Madam President, as I close, I am happy to speak on those few amendments that really spoke to electronic services. And, of course, the other amendments given really seek to define and to make good several other pieces of legislation. Madam President, I wish to thank you.
Honourable Senators, at this point, the sitting will be suspended. Before the suspension, two things. One, when we resume, I'm hoping that there will be at least 10 senators in the chamber. And two, any senator who has any amendments, if you can please work on the amendments with the parliamentary staff now so that we can have a smooth functioning of the committee. All right, so this sitting is now suspended until 1:30 p.m.